Support comes from the St. Louis Public Library Foundation. During these challenging times, free access to digital resources is a necessity. You can help our community stay connected. Support your St. Louis Public Library at slpl.org.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. When does when mean when? And when does it mean only when? The Missouri Supreme Court spent an hour discussing that question this month, and they came to a conclusion that surprised some legal experts. Also, the former superintendent of the St. Louis Public Schools says she was discriminated against, and a journalist says she was wrongly ordered to jail by a judge. Who's right? Who's wrong? Who's likely to be reversed on appeal? These are big questions for legal experts, and today we have three with us. Yes, today is our monthly Legal Roundtable. Today we've got a great panel. I'm so excited about this one. We're joined today by Sarah Swadesh. She's a labor and employment attorney. She's in private practice at the law office of Sarah Swadesh. Sarah, welcome.
It's great to be here.
And we're also joined by Susan McGraw. She's a professor at the St. Louis University School of Law and the director of its Criminal Defense Legal Clinic. Susan, welcome.
Thank you, Sarah.
And today, a real treat, we're also joined by Judge Nanette Baker. She served as Chief Magistrate Judge in the Eastern District of Missouri from 2016 to 2021. She previously served on the Missouri Court of Appeals in the Eastern District of Missouri for 6 years and was Chief Judge from 2008 until 2009. She was the first African-American woman to be appointed to that court, and she has also been a circuit court judge in the city of St. Louis. That is a wealth of experience. I am always excited to get to tap into that. Judge Baker, welcome back.
Thank you.
So this month, the Missouri Supreme Court spent more than an hour discussing the meaning of the word when. And then also this month, it rendered its verdict. That verdict has big consequences for the congressional maps that were pushed by President Donald Trump and voted in by Missouri Republicans. So Judge Baker, why was the definition of when such a big question in this case?
Well, as you mentioned, the HB 1, the House Bill 1, repealed the congressional districts adopted in 2022 and established new congressional districts. They're referring to this as mid-decade redistricting. And, of course, this map targets the 5th congressional district held by U.S. Representative Emanuel Cleaver of Kansas City. But the crux of the argument there was the meaning of the word when. Well, Article 3, Section 45, which is the constitutional provision here, states when the number of representatives to which the state is entitled in the House of the Congress under the census, the General Assembly shall, by law, divide the state into districts corresponding with the number of representatives. And this was supposed to be done, at least the appellants were arguing, that it's when the census takes place, that's when redistricting can happen.
I mean, as a non-lawyer, I'm hearing that sentence. I'm saying, when this happens, then you can do this. That seems pretty clear-cut.
It did seem pretty clear-cut, and Justice Zellfisher, who actually wrote this opinion, was one of the people who asked one question in that argument, and he asked the appellant's lawyer, do you believe that when means only when? And the lawyer, of course, responded, yes. Well, the Supreme Court decided after hearing the arguments, of course, of the respondents, that when does allow redistricting later on in mid-decade. And their decision basically stated that when did not limit the number of times that the redistricting can occur.
So when doesn't mean only when.
Right.
When means this happens and then you can just keep doing this.
Right. And that was their decision. The dissent, of course, there was a very long dissent that went into the legislative history that argued, of course, the other side and stated that it should be based on when the census is done. And the reason is because that's when you have the best idea of how many people there are in each district.
And as we mentioned, this is something that some legal experts had come in thinking when meant only when. Susan, are you surprised that they ended up finding that when does not mean only when?
I was surprised. I am concerned. I think that if you take this to its, rational end, are we going to start doing it every year?
I mean, we could, right?
Right. And I think we also need to note that this was targeted towards a person of color who is a representative. And that makes me wonder what role race may or may not have played in making this decision. And anytime we are considering race, it's really constitutionally problematic.
So, talking about the U.S. Constitution, is there any chance this could go from the Missouri Supreme Court's decision to say, well, we got to get the U.S. Supreme Court involved here?
I don't know the answer to that. Oftentimes, states are left to make their own rules, but when you think about this, is there going to be then one requirement for federal ballots and one requirement for state ballots? I think when we bring the voter ID law in conjunction with this, it's very, very murky.
I want to mention one other thing, and that is St. Louis Public Radio correspondent Jason Rosenbaum was kind of obsessed with this case. People had to tell Jason, can we talk about something else here? But his analogy was the Air Bud rule. This is a reference to the 1997 Walt Disney film. There's a referee in that movie that allows Buddy the dog to play basketball because, in his words, there ain't no rule that says a dog can't play basketball. So, Sarah, is the conclusion here, there ain't no rule that you can't draw new maps whenever you'd like?
So before I get blasted by my brilliant colleagues at the table, it's a terrible policy. The pendulum will swing back towards Democrats. We're going to have new districts drawn every year. It'll be a nightmare. But I don't necessarily disagree with the plain reading of the Missouri Constitution. The Missouri Constitution is silent as to when, but more importantly, it's silent as to successive redistrictings that can be done. And so the proponents here were asking the judges to insert the word only when. And from a sort of judicial activist position, we don't want judges adding language. We don't want judges making policy. And so I think the Missouri Supreme Court abstained from making policy. I'm sure they all went into their chambers and said, well, this is going to be a disaster. But they followed what the Constitution says, and I think they will kick it back to the Missouri legislature or the voters to say, you guys need to insert the word only. And so the decision is consistent with the federal judge. I think it was Judge Limbaugh who said the exact same thing. He said, there's no definition, there's no explanation in the Constitution as to how many times a redistricting can be done. So the Missouri Supreme Court is consistent with the Missouri federal court. Do I like it as a policy? No. Do I think they just absolutely got it wrong? I don't.
Judge Baker, I know there was a very lengthy dissent in this case. What kind of points were they bringing up there?
Well, the dissent, their points had to do with a time and place restriction. So one of the things that they stated was they're arguing that Section 45 was added to the Constitution to limit the times or modes of proceeding. And so their point was that the constitutional provision states how and when redistricting should occur. And so under their construction of this, the plain reading does say when, which is after the census, and how, which is that they have to draw contiguous compact districts. So that was the crux of their argument, was that it doesn't, that is the limit. The limit is already in the provision.
For those of you listening, you may have a question or comment about this decision by the Missouri Supreme Court or anything we talk about today. You can call us at 314-382-8255. That's 314-382-TALK. We'd love to hear from you. Susan, this does seem to open the door to say we could do this as often as we want to do this now. If when doesn't mean only when could mean every year.
Right. And the bigger problem, does when only mean when in every Missouri statute? I mean, this opens the door to a lot of problems.
Would that then be an effective argument if there's a statute that says when you do this, then you have to do that? And I say, well, in this ruling, the Missouri Supreme Court said when doesn't mean only when. That's an effective argument potentially.
Yes, they've set the precedent.
Okay, so they have now defined when in a way that feels somewhat new to the two of you. Sarah, I see a skeptical look on your face.
Sure. You use my favorite sentence I like to use with my child, which is when, then. When you clean your room, then you get the dessert. And again, my brilliant colleagues are inserting a word that does not exist. The word then is not in the Missouri Constitution. And so I think we are straining to put parameters around it by inserting only or inserting then, and it's simply not there.
Something I find myself wondering about is what role history plays in this. Like, what is undisputed is that we've always treated it as when this happens, then we do this. You don't get to do this another time. Does that matter legally, or is it only the plain language of the law? That's probably a 15,000 volume book that needs to be written. But is there sort of clear thinking on that question?
Well, obviously, that was one of the things that the dissent focused on, what the legislative history was, and the fact that since this was enacted, there's only been redistricting once in the 10-year period. And so it was, of course, a positive for the dissent that they thought it was a good point. However, the majority states that it's not only when.
It's interesting to see the liberals arguing that we need to pay careful attention to precedent, and the conservatives are saying, let's just throw this out. It feels maybe like a little reversal of what those words even mean.
Right. And I think the bigger lesson here for people who aren't lawyers who are listening is just how malleable our laws are. We think we make laws that'll withstand all sorts of tests, but in the end, you cannot put every word, consider every context to meet every fact pattern in the law.
And isn't that why lawyers continue to have a robust employment situation? We're talking today to our Legal Roundtable, 3 lawyers willing to share what they know about the law with all of us. That is Susan McGraw of St. Louis University School of Law. We're also joined by Sarah Swadish of the Law Office of Sarah Swadish and Judge Nanette Baker. We need to take a quick break. When we come back, we're going to talk about something else that Missouri Republicans have been up to, and that is a sweeping crime bill. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from Gemma, architects, planners, and designers seeking to bring joy to their clients and communities. Details at gemastl.com.
Welcome back. I'm Sarah Fensky. I'm here with our Legal Roundtable. This month, we're joined by Susan McGraw, a professor at St. Louis University School of Law and director of its Criminal Defense Legal Clinic. We're also joined by Sarah Swadish, a labor and employment attorney in private practice at the Law Office of Sarah Swadish, and Judge Nanette Baker. She's a former chief magistrate judge in the Eastern District of Missouri, a former judge of the Missouri Court of Appeals in the Eastern District, and a former circuit court judge in the city of St. Louis. You know, we were talking about these Trump-backed maps. They won a big victory in the Missouri Supreme Court. They are, at this point, signatures have been submitted where voters will get to decide whether they want these maps to go into place or not. And now with the precedent we have, any new map, I suppose, it can come out every year, and every year the voters could vote it up or down. There was a ruling this morning. A Cole County judge ruled that this new map created by Republicans is in effect. That's a big win for them. There's a group called People Not Politicians that are trying to put this up to a vote. They contended that because they had turned in the signatures that this map doesn't go into effect. The Cole County judge said no. Now, we can guarantee that is going to be appealed. That is going up to a higher court. The higher court will decide which map is in effect. But that's another loss for the people trying to stop these maps. So, and again, if you have questions or comments about this, you can give us a call at 314-382-8255. That's 314-382-TALK. So the Trump-backed maps, these are not all that Missouri Republicans have been up to lately. They also passed a sweeping crime bill. This is headed to Governor Mike Kehoe's desk. He has not yet signed this into law. So who knows? He might be listening today, trying to decide how he feels about this bill. Susan, how do you feel about this bill?
I feel that this bill is just another attempt to solve crime by locking up more people. And it does that in several ways. It increases the mandatory prison sentences for people. But I think, the biggest, most concerning change to me is that it changes the classification of juveniles and when they can be certified as adults. What I think your listeners should know is that an adult who is certified or made to stand trial as an adult enters the adult criminal system.
So let's say I'm a 14-year-old and we think that I have done something very bad at this point. I could, at this point, under this crime bill, I could be certified as an adult. What does that mean for the journey of my case?
Well, it would move the case from juvenile court, where the efforts are more on rehabilitation of a child, to an adult court, where the emphasis is on retribution and punishment. The most concerning part to me as a person who has several clients with civil rights cases out of prisons and jails is that small people in adult jails and prisons are victimized. And it doesn't even mean child defendants, just people who are small in general, who have certain kind of offenses, are really prey. And
when you're talking about prey, you mean violence, you mean rape?
I mean sexual violence, I mean rape, I mean assault, anything from people making sure you never get your food tray so you're hungry all the time, that you never get to use the phone. To put a 14-year-old in a facility that houses adult offenders, and very serious adult offenders, guarantees that that child is going to have much worse outcomes later in life. Even if we set aside the violence and the sexual violence, studies have shown that these kids who are in adult facilities, 50% of them report suicidal ideation. They have more mental health problems. Their physical health is considerably worse. And so I really am afraid by locking up more children, we are guaranteeing poorer outcomes, not just for those kids, but for our communities.
Tell me, the way this law is written, is this something where it gives the judge the right to certify them as an adult, or is this something where it's pushing judges into treating them as adults?
I don't think it pushes them, and I know the judges around St. Louis, they're not going to be swayed by this legislation. But it does open the door to allowing more young children. I mean, Sarah, the Supreme Court of the United States has accepted brains are developed at about 25 years old. Now, I don't know who else has a 14-year-old, but they are not equipped for dealing with adult situations in or out of a jail or a prison.
Judge Baker, this feels like such a sea change from where things were going. As a journalist, I've covered issues involving juvenile crime, and it felt like the Supreme Court ruling that came out, now it has to be at least 10 years ago, that this really had states changing how they dealt with these things. This feels like it's going back to how things used to be.
It really does, and it's very unfortunate because there have been many studies done about the brain development in young kids and in teenagers especially. And again, yes, their brain doesn't mature until about age 25. They have issues with impulse control and emotional regulation and those types of things. And a lot of people in the criminal justice system had understood that. A lot of courts had understood that. And things were being put or have been put into place in many jurisdictions to help them with rehabilitation rather than incarceration. So this really is a step backwards.
Do you think, as far as our judges here, do you think they'll largely be averse to using these tools? Or do you think that, there's a chance there'll be a large number of young teens who are going to end up in the adult system?
Judges are individuals.
Yeah.
So you will have some who will have this now available to them to potentially incarcerate these young people. I do think that many judges are enlightened and understand the juvenile brain development and those types of things. And so I do think in general, we won't see in the city and the county, we won't see that type of
But this is obviously a state law. There's a lot of other counties out there. Sarah, any thoughts on this one? I know criminal justice is not your specialty as an attorney, but
It is not. What jumped out at me is two things. It's easy to punch down on crime. Politicians, it's an easy win for them to say, I want to be tough on crime. But what jumped out at me is this bill has a 1% sales tax to build these new facilities. And so at the same time, our legislature is saying we need to get rid of income tax. They're wanting to do a regressive 1% sales tax to accomplish their mission.
So I want to go to the phone lines. We actually have Kathy, who's calling from St. Louis with some thoughts on this. Kathy, hi, you're on St. Louis on the air.
Hi, thanks. I was just calling about the juvenile transfer bill for children being certified to stand as trial as adults. Mm-hmm. It's my understanding that if a child is transferred and then they are acquitted in adult court, meaning they were found innocent by a jury or the prosecutor decided no, there wasn't enough evidence to prosecute them, that they are forever after that treated as adults. And so you can't go back to juvenile court if they commit a minor crime or get in trouble for some other reason. So that would be a concern of mine.
Kathy, that definitely, I can see why that would be a concern. Susan, I'm wondering if in your experience, does that seem true, what Kathy is worried about there?
Yeah, I believe it's statutory that once you have been found unamenable to treatment in the juvenile courts, you are forever subjected to adult courts. Now, I think that applies even if someone is acquitted, but I am not certain.
Okay. So it sounds like you think Kathy might well be right about this.
Oh, I think so,
yeah.
Yes.
Okay.
Yeah.
Kathy, it sounds like this is an issue that you're really up to speed on. It sounds like you probably have some concerns about this bill as well.
I'm not necessarily up to speed on it, but I used to practice in juvenile court, and so I know that if that was always a concern of ours when they were trying to certify children, for a crime, and then they really hadn't investigated it very well because it's something that happens early on after a kid is arrested. Mm-hmm. And so, after further investigation, it may have been determined that the kid was innocent, but because they got transferred so quickly, that we weren't able to, or that we wouldn't have been able to help them. So it's just a concern, that's all.
Yeah, well, thank you, Kathy. Thank you very much for sharing your expertise on that. And yeah, that's a very interesting perspective. I had not been aware of that. And I can see, sometimes when they bring cases, the facts just haven't been sorted out yet. And, thank God the way our system works is people can be found not guilty. But if that then continues to hold, that's a problem. Judge Baker, with this law, any other concerns that you have or anything else that stuck out to you as you were reading about what the legislature's doing here?
Well, actually, the 1% tax was also a concern of mine. I mean, I noticed that it almost seemed it was an afterthought or something. But when you think about the impact that has on communities, adding additional taxation and just to incarcerate more individuals. And the problem with the incarceration of juveniles is that it likely leads to more recidivism later. If they have opportunities for rehabilitation or diversion court or something along those lines, there are better outcomes than there are putting them in jail.
So we should mention Governor Mike Kehoe has until March 27th to sign this bill, to veto it, or for it to become law without his signature. And some reporting has showed this new bill comes with a price tag of almost $870 million, and that would be attributed to the need for a new prison. Susan.
And if I can add, think of what that money could do in terms of tutoring, extra income for the families of these kids, building more basketball courts, having activities that these kids could engage in the evening.
Yeah.
That's where that money should go.
And that $870 million, I should say, this is not journalists who've come up with that number. That is coming from the fiscal note on the bill. So you can take that one to the bank. I want to change gears here. We've been talking about some pretty heavy stuff. Here's another case, but this is an employment law case. This is what Sarah Swadish is our expert in today. The former St. Louis Public Schools superintendent is suing the district, Millicent Borashade, who was fired last year after just, I believe, 15 months on the job. She says her performance was, quote, exemplary. She says she was trying to blow the whistle on everything from payroll fraud to misuse of public money. She says she was subject to a witch hunt. She's suing not just the district, she's also suing the teachers union, which had come out against her during her tenure as superintendent. Sarah, you've now read this lawsuit. Do you think she makes a compelling case?
I do. Certainly under the whistleblower statute, she does. Under the whistleblower statute, she has to show that she disclosed some violation of law, that there was an adverse action, and then some causal connection between them. And so in this petition, she spends at least 6 pages talking about all of the unlawful violations. She disclosed issues with I-9s, misuse of public funds, Title IX violations, ADA violations. I mean, it's 6 pages of unlawful activity going on. So she's clearly made a protected report. The adverse action is her termination. That's pretty obvious. But now she has to connect the dots between her report and her termination. That's what we call the causal connection. And, I think she's going to have some pretty good arguments. She was terminated without cause, meaning there's no poor performance here. You're just fired. And so it begs the natural question of, well, why did you fire her? Is it because of these complaints she made? And if they had fired her with cause, she would have been entitled to a hearing, and I'm certain she would have brought all of these allegations of unlawful activity forward. And I think the school district probably wanted to avoid any of these allegations coming out, and so they fired her, but they are still paying her. And I would bet a donut they were hoping that if they continued to pay her, she would consider it a 6-month sabbatical and go away. But that is not what happened.
Yeah, that is not at all. I should mention, as a print reporter, moonlighting in the radio sphere, I had no idea how to pronounce this woman's name, and she was our superintendent for 15 months or so. It's Borashade. Now we all know. I'm going to set everybody, including myself, straight here. Millicent Borashade. Judge Baker, what strikes you looking at this lawsuit and her attempt to sue the district and the teachers union?
It was a bit surprising that she also added the teachers union in there. And I do think that the whistleblower allegations are probably the strongest part of her lawsuit. It will be interesting as the facts come out, because I'm sure the facts on the other side are going to contradict what she is saying at this time. But I do think that her allegations under the whistleblower statute I actually thought some of those allegations were surprising.
Yeah. It's interesting because people really were against her. I think she was perceived as being part of the Seattle regime that many St. Louisans are like, what are these Seattleites doing to our school district? Nobody really gave her a chance, I think, in the court of public opinion. Just hearing her side, it makes one wonder.
It does.
As you said, we will also at some point hear the other side, which we don't have yet. Sarah, something else that struck me on this. She's also saying that she was discriminated against because she's a black woman. Now, this is a district that has a black woman as president of the school board. Her predecessor in the superintendent's office was a black woman. Her successor, the interim, is a black woman. Does that matter?
It does not in the slightest. Same gender, same race people discriminate against each other all the time. I have African American clients, and they come in and they say their supervisor told them to pull up their pants or don't make us look bad. You can still be racist against your own race. You can still be sexist against your own race. I've had female clients come in and their female supervisor says, you need to do your nails. You need to keep your nails up. So the idea that you can't discriminate against your own race or sex is just implausible to me.
But I'll say if I'm a juror and I'm being presented with a black woman who's been fired by an all-white school board, and this is the only black person they've ever elevated to a position of power, I'm going to go, boy, I am skeptical about this school district. Whereas if I hear this set of facts, I might be more likely to go, I don't know, this district has a long history of promoting black women. Does that make things harder as a lawyer, even if the law itself is maybe different?
It could. You would want to hear anecdotal evidence that accompanies it. And so what Miss Borashade, thank you, alleges that she was in the position, she was performing well, test scores were going up, she was figuring out how to consolidate schools and get rid of dilapidated buildings, that she was doing her job, yet the black school board chairman of the board came to her and said, you need to talk to my husband, an African-American man. He'll teach you how to do it. You need to talk to the former superintendent. He'll teach you how to do it. And from her perspective, she's doing the job. Why are you telling me to go to talk to some man?
Susan, what are your thoughts on this one?
I don't have an opinion on it. I think it's going to be troublesome because the school board and our school system is not functioning the way that it should.
Yeah.
And I wonder if going into a jury trial, the jurors who are St. Louis City residents would say, we know what was going on there, and you, like you said, are part of this Seattle group.
I think to address that, she was terminated without cause. And while Miss Scarlett, the former superintendent, had all these allegations of self-dealing, misappropriation, there's not one by the union, by the school board, by a parent that said Miss Borashade was self-dealing, that she did anything wrong. There's not one allegation anywhere. The allegations are that the test scores went down, and I think that's part of her defamation claim is actually the test scores were going up. So maybe there's the perception that she was involved in the Seattle crowd, but that's not reality. And when I think it gets before a jury, I think the jury will be able to set that aside.
Right, and I wasn't arguing the facts. I'm a trial attorney. It's what I've done for my entire career. And I do think that she will have to overcome this general sense of distrust of the St. Louis school system. In order to successfully.
Yeah, that's sort of like your gut, the juror might be listening to their gut, not to the letter of the law.
Exactly.
I think that actually helps her. The distrust is with the board. They keep hiring terrible people, and she was actually doing the job. Why? They have no reason to distrust her. She was consolidating schools. She was increasing test scores. There's no distrust of her. It's what is the board doing? What is the self-dealing behind them, going on with them? And some of the allegations were that the union was coming to the board and dealing behind Borashade's back for promotions in exchange for firing her. And so I think when those emails and texts come out, it may absolutely destroy the credibility of the board.
You guys are making me want to be on this jury. Judge Baker, is this a case you'd want to preside over?
If those emails and in discovery, if those things come out, this case will not go to trial.
You make an excellent point there. Yeah. Everyone will have good cause to settle at that point. So I want to bring up another employment case that was in the news this month. This involves the head of St. Louis County's MWBE program, which seeks to make sure that people of color and women can work in government programs. Now, he says he was retaliated against for suggesting changes to the program to the county council. And of course, the county council is at loggerheads with county executive Sam Page. So you have to wonder, is this kind of like sleeping with the enemy and then you get fired for it? This case, Sarah, do you think this guy has a solid claim here?
I'm a little worried for Mr. Adams. So, same as Miss Borashade, It's a whistleblower claim, same statute. Mr. Adams has to prove he engaged in protective conduct. There's an adverse action, and they're causally related. Adverse action is obvious here. He's been suspended. The causation seems pretty obvious. There's a letter to him that says you're being suspended because you went to the board and talking about the procurement division. So it's in writing why he's been suspended. But I don't know if he's engaged in protected conduct. And what I tell clients is not all retaliation is illegal. So if you call your boss's wife ugly and you're fired, that's retaliation, right? You were fired because you called the boss's wife ugly, but it's not illegal, right? It's not illegal. If you're complaining of race, age, gender, national origin, disability, or certain issues under statutes, then it's protected. So in this case, Mr. Adams claims that he went to the county board and he said that his department, which is the Minority and Women-Owned Business Enterprise, should not be under the Department of Procurement because their goals aren't aligned. Department of Procurement is going to want things cheapest, fastest. Perhaps the Minority-Owned Business Department, they don't have those same goals. Mm-hmm. And so his argument was they should be separate. And then he gave proposed language on why they should be separate and some legislation on making that happen. And so the letter that he got said you shouldn't have gone to the board to voice your concern that these minority-owned business and Department of Procurement should be separated. And I think, did he engage in any protected conduct? He's not complaining of race, age, gender, national origin, disability. I don't hear him complaining of a violation of rule, law, regulation. I don't hear him complaining of mismanagement or gross waste of funds. I don't hear protected activity, but this is still at the beginning phase of the lawsuit. It was only filed 3 weeks ago. I assume depositions will occur and maybe some of those details will get flushed out. But at first glance, I would want to see more protected activity in the lawsuit.
So just saying this is kind of a poor organizational structure, that is legally different than saying this is illegal what's going on here. I'm coming before the county council. I'm blowing this whistle. This is not a blowing the whistle. This is more I really don't like the way my department's organized.
Yeah, and that's not illegal, but it's perhaps not very savvy to go to your boss and say that, but it's not illegal if you're fired for it. It's not illegal if you're fired because you say you're a Cubs fan. It's not illegal if you say, if you work at the GM plant and you say, I hate GM cars, I'd rather drive a Kia, and they fire you. Well,
they can do that.
They can do that.
Boy, I got to remember, you don't want to call the boss's wife ugly. That's my takeaway for Sarah Swaddish's tutorial in employment law. We're talking today to our Legal Roundtable. That is Sarah Swadish, a labor and employment attorney at the law office of Sarah Swadish. We're also joined by Susan McGraw of St. Louis University School of Law and former Judge Nanette Baker. We're going to take a quick break. When we come back, a judge orders a journalist to be jailed. Well, the appeals court said not so fast. This is St. Louis on the Air on St. Louis Public Radio.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.
Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha because today is our monthly Legal Roundtable. We get to pick the brains of some of the smartest lawyers working in the business. It is always such an educational and often a fun time. We're joined today by Judge Nanette Baker, a former Chief Magistrate Judge in the Eastern District of Missouri, a former judge of the Missouri Court of Appeals in the Eastern District, and a former Circuit Court judge in the city of St. Louis. We're also joined by Susan McGraw, a professor at the St. Louis University School of Law and director director of its criminal defense legal clinic. And last but never least, Sarah Swadish, a labor and employment attorney at the law office of Sarah Swadish. So a Franklin County judge ordered a journalist thrown into jail this month, but the appeals court did end up quickly intervening. Judge Craig Hellman ordered Kathy Utley of the Herman Advertiser Courier newspaper to go to jail for 5 days after she was seemingly caught recording portions of a death penalty trial that was taking place in January. The judge had issued an order before the trial prohibiting all electronics that could record or live stream. Well, they apparently found videos on her phone. He ordered her into contempt, which seems like so far so good. If a judge has an order like this, it's a big problem to violate it, right? So, Judge Baker, where did this go wrong?
Well, where it went wrong was he did order her in contempt for violating his order, and then he committed her to 5 days in jail. Well, he didn't actually commit her because he had to do an order of commitment. So what happens was he had her jailed. Her lawyer filed a writ to the Missouri Court of Appeals. And having been on the Missouri Court of Appeals, I will tell you, judges get writs all the time. And many times, nothing, we deny the writs.
Yeah.
In this case, the writ was granted because the judge failed to file an order of commitment. That is necessary in order for him to have jailed her.
Is this just a simple piece of paperwork where he could have said, order of commitment, here's my signature?
Actually, yes. He had to make some findings and do the order of commitment. And he did not. I believe that he may have overreacted. It is frustrating as a judge when your orders are not being followed. But their contempt can take a lot of different forms. He could have fined her. He could have barred her from the courtroom. He could have done a lot of things short of jailing her. But if you're going to jail someone, you're going to take away their freedom, then you have to do it the correct way.
Do you think if he had ordered her barred from the courtroom and her lawyer had gone up to the Court of Appeals and tried to get that blocked, that the judges there would have acted quite so quickly?
No.
No?
I do not believe so.
They take jail very seriously.
Yes.
Okay.
Yes.
Susan, we all know courtrooms where they're like, you are not allowed to record this. Y'all put your phones away. Is this something where we can just sort of freely ignore that?
No, I really don't think it is. And there are a number of problems with having phones in the courtroom. There are times when people who testify are doing so at great personal jeopardy, and to allow someone to video what they're saying or to take their photograph can put that witness at a lot of risk. So I am not a person who thinks we should all be able to record or take photographs in the courtroom for that reason. I worry about the criminal defendant's right to privacy and the witnesses. Maybe he overreacted, maybe he didn't, but she was clearly in violation of a rule that most judges have in their courtrooms.
Do you think if he had just done this order and filled out his reasons for holding her in contempt, she could have gotten stuck with a 5-day jail stay?
I think it is possible, and judges do take this seriously. And not to push the point too hard, but they took off videos and recordings off of her phone.
Yeah.
So it was not just that she had the phone on in the courtroom. She had clearly violated the judge's order.
I was fascinated by how she said that it had happened by mistake. I was like, how do you accidentally record a video? That I'm pocket dialing people all the time, but to record a video, that feels like you gotta kind of put a little thought into it. Sarah, would you ever attempt that in a courtroom if the judge had barred it?
Well, I'm obviously going to say no. But
Even
don't
as
grab
you
my
secretly
phone.
record?
But don't take my phone. I think that's what compounded it. It was very clear instructions, and it was the murder penalty phase for murder conviction. It's sensitive. It's highly sensitive. And the judge had pulled everyone in and said, absolutely not, no recording. And not only did she flagrantly violate it, she lied about it. And I think it really compounded. Maybe if she had said, I'm so sorry, I couldn't hear. Maybe if she had some poor excuse. It could have gone better, but I think the line just tipped it over the edge.
Judge Baker, having, I'm sure, been in some situations like this, would you rather if she had just said, yeah, I screwed up? Do you think you would have still tried to send her to jail?
Well, I've never sent anyone to jail. Okay, that's wrong.
I believe you have.
For contempt, but actually I was going to say I hadn't sent anyone to jail for contempt, but I have.
You did.
But it was a much more egregious situation. It was someone who was just ignoring court orders. I've had the situation in my courtroom where people were using their phones, pulling out their phones, obviously videotaping. You can see it from the bench. You can see what they're doing. And I would always just get the marshal to go remove them, take the phone, remove them from the courtroom. In this situation, it was a journalist, which actually I think makes it worse because she was aware, even though she said she wasn't aware of the media policy, there was a policy that you are not to record. And don't get us wrong, the decision by the Court of Appeals was definitely not saying that she should not have been held in contempt. It was just that the process used was not the correct process.
So do you think we'll now see this judge come and use the correct process and send her to jail now, or has that ship sailed?
I don't believe that he'll send her to jail now.
He's
No.
maybe just, he's
But
not
I
as
think
mad.
the next time it happens, he will know the correct process to use. And so will every other judge who needs to use it.
So the journalists should all be on notice. This is good for me to remind my staff of when I return to the office this afternoon.
And if it makes people feel any better, I'm not allowed to do that in the courtroom, and I'm an attorney, and I have business there.
I think we've all just gotten so used to recording things. People don't know how to take good notes anymore. People just go around routinely taping phone calls. It didn't used to be like that. And so courthouses are sort of the last zone where you're not allowed to do that. And people are thrown. They don't know how to handle it. All right, last couple minutes here. County Executive Sam Page, he's alleging selective prosecution. He's facing felony charges of stealing with allegations he used county dollars not to benefit himself, but to send a mailer advocating against a ballot measure. A very unusual case here. His legal team has filed motions saying in effect that lots of other public entities have done the same thing. They were never prosecuted. They say the difference is that he's a Democrat who had tangled with Republican leaders. Susan, this idea of selective prosecution, is that likely to hold water with a judge?
I'll tell you, it's a high bar, and I've looked at it before thinking I could throw it in on one of my cases, but this might have legs because they might be able to make a nexus between doing this for the purpose of encumbering a political opponent. But you have to show real intention and malice on part of the person who brings the charges. That said, it doesn't make it less illegal that you did it.
Yeah, so you can't just show, oh, I went out and murdered somebody and they're not catching any murderers, so I should be allowed to go free. You have to show they're coming after me because they hate me. That's sort of the critical part.
Not necessarily, but that they hate you, but that they target you only because of your, and I'm paraphrasing, only because of why they don't like you. Mm-hmm. People do these kind of things all the time. It's a simple, one would think it'd be a simple mistake to make. And the fact that they've let it go for the 300 people who did it before him, but then called him on it, might give them really a chance.
Judge Baker, what do you think?
I think it's the best argument they have. Because I think that in making this argument, basically they're saying what he was doing was illegal. He's just the one that got caught or the one that they're going after. So I think it is a good argument for him, but will it be successful? I think that's a really big question.
Yeah. Sarah, I'm going to give you our final, you can sort of play the judge here. What do you think? Do you think selective prosecution is going to fly in this case? Whether or not it flies in the circuit court, do you think the appellate court maybe would take a close look at this?
I honestly don't know, but I don't think it's an admission that he did anything wrong. They still have to prove mens rea. They still have to prove an intent to misappropriate, an intent to, distribute improper political mailers. I think that's going to be hard. He's dropped his claim for a speedy trial. The state's going to have to come forward with their evidence. I think the Republicans, while they're in control in Missouri, it certainly doesn't seem to be the trend. I actually suspect he will walk.
So you think this will be the get out of jail card he's been waiting
I don't
for?
think he will get convicted.
Do you think it's because you don't think they'll be able to prove the case?
I don't think they'll be able to prove it.
That's the
these
question.
stealing charges,
Yeah, I don't think they'll be able to prove it. And he's dropped the claim for speedy trial. I mean, there's going to be a whole different atmosphere.
Well, Sarah is now on the record. We are going to hold her to this as it shakes out. We'll talk about this on a future month. Sarah Swadesh of the Law Office of Sarah Swadesh, thanks for joining us.
Thank you.
And Susan McGraw of St. Louis University School of Law, thanks for joining us.
Thank you, Sarah.
And Judge Nanette Baker, thank you.
You're welcome. Glad to be here.
This episode was produced by Sarah Fensky.
Audio engineering and podcast design by Aaron Dorr.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.